So you've decided to do some crimes, who hasn't? Well, thanks to those legal myths that TV shows and fake lawyers on Reddit continue to spread, you're probably in for the biggest surprise of your life. It's going to come as a shock, but real life is not a Medea movie.
Forgot to Mirandize her?
That old woman got the strength of any man.
I've got to let you go.
You gotta let me go.
Now, the Miranda warning, which starts with "you have the right to remain silent," comes from the 1966 Supreme Court case of Miranda versus Arizona. Before the police can interrogate someone who is in custody, they must inform them of their Fifth and Sixth Amendment rights, their right to remain silent and their right to an attorney. If they don't, any statements made during the interrogation can be thrown out under the exclusionary rule, which is the legal doctrine that bars illegally obtained evidence from trial. But Miranda only protects your words, not your actions. So if the cops find a kilo of meth in your trunk, no amount of unread rights will make that disappear. On top of that, according to the Supreme Court, Miranda only kicks in if there's a custodial interrogation. If a suspect voluntarily comes to the police station and talks, it doesn't mean he or she is in custody. The takeaway? Miranda applies when a reasonable person would feel they're not free to leave. If the police arrest you for that kilo of meth in your trunk but don't ask any questions, no warning needed. If they ask you questions before you're arrested and you answer voluntarily, still no Miranda required. That's why failure to read Miranda rights isn't a get-out-of-jail-free card. But if you ever do find yourself needing a get-out-of-jail card, call Farrell Marino, 7939801.